Yes, Mr. Kelly.
My Lords, I'm now going to move on to the first of my 4 core submissions, which is going to address the court on the position pre-2013 with reference to some of the materials which the court has already had reference to. With that in mind, please can I ask my Lords for you to turn to page 407 of the Authorities Bible. My Lords, this document is the explanatory notes to the Access to Justice Act 1999.
Yes.
And the first material paragraph is at paragraph 22 on page 409. And the first 2 sentences are contextual and explains that there is a community legal service for civil legal aid and a criminal defence service for criminal legal aid.
Yes.
Over the page, paragraph 23 is an explanation of the functions of the community legal service. A reference to what's described as a funding code. Towards the bottom of page 410 is the criminal defence service. And if I could ask your lordships to read paragraphs 30 and 31 on page 411. Well, if I can now ask you to turn to page 418. Paragraphs 81 and 82 explain that the funding code will replace the merits test for civil legal aid.
Yes.
And at paragraphs 88 and 89 at 419. There's an explanation that Section 10 enables the Lord Chancellor to set financial conditions to apply to people receiving services funded by the CLS fund, albeit that the effect of Section 10 is generally to replicate the provisions of the 1988 Act. And finally, my Lords, if I could ask you please to turn to page 423 in its paragraphs 118 and 119. This is the Criminal Defence Service, and the reference to Section 17 as being the provision which empowers the Lord Chancellor to make regulations about how the new power should be used. The Access to Justice Act itself is at page 318. It starts behind tab 15. If I perhaps could orientate the court first at page 315, which is section 6 of the 1999 Act. Section 6 pertains to community legal service, that's civil legal aid, is 6.6 provides that certain services, i.e. those in Schedule 2, cannot be the subject of civil legal aid, so that's your boundary disputes and such like. Page 317 is section 7.1, again this is civil legal aid, and it provides that the Commission may only fund services for an individual as part of the CLS if his financial resources are such that, under regulations, he is an individual for whom they may be funded. Section 12, which is on page 318, is the Criminal Defence Service. Section 12.1 provides for the establishment of the Criminal Defence Service for the purposes of securing that individuals involved in criminal investigations or proceedings have access to such advice, assistance and representation as the interest justice require. Section 12.2 provides for the definition of criminal proceedings, and section 12.2f deals with contempt in the face of court. And section 12.3 provides that the Commission shall fund services as part of the Criminal Defence Service in accordance with 13.250. Section 14.1 over the page at 320 provides that Schedule 3 has effect, and the Commission shall fund representation to which an individual has been granted a right in accordance with that schedule.
Sorry, just go back to 12.2. Did 12.2G ever become relevant?
Not as far as I'm aware.
No. 14.
Section 14.1, we're still in criminal legal aid territory, so to speak. 14.1 provides that Schedule 3 has effect, and the Commission shall fund representation to which an individual has been granted right in accordance with that schedule. And then if one goes over the page, section 17.2 is the 17.2 and 3 is the power to provide for regulations, which ultimately gave rise to the 2001 Act. And then over the page at 323, we have Schedule 3, and paragraph 5.1 of Schedule 3 simply provides questions to whether a right to representation should be granted should be determined according to the interest of justice. So there was only an interest of justice test so far as the provision of criminal legal aid was concerned, which is consistent with the explanatory notes to the 99 Act that I've taken your lordships to, and it's section 17 that provided the authority for the Lord Chancellor to make regulations, and it is under section 17 that the 2001 regulations were made, and that is made clear on the front page of those regulations at page 330. The Lord Chancellor, in exercise of the powers conferred on him by section 17 of the 99 Act, makes the following regulations. The definition of criminal defence service on page 332 links back to section 12 of the 1999 Act. And my lords, I've made my submissions on regulations 3 and 4. So far as regulation 3 is concerned, what is important is that the risk of a RDCO is a function of the fact that funding is being provided by the Criminal Defence Service. So the gateway criteria, so to speak, in Regulation 3 is not whether proceedings to be heard in the civil jurisdiction or the criminal jurisdiction. It is simply, are the criminal proceedings funded by the Criminal Defence Service? And that, my lords, is replicated in the current arrangement, so to speak, whereby with criminal legal aid in the Respondents' submission comes the potential for a recovery order. And what matters when one is asking oneself about whether a recovery order is going to be engaged is whether the funding itself was a function of criminal legal aid. It's not the stage of proceedings necessarily, and they might be relevant depending on the regulations engaged. But what pervades both the previous regime and the current regime is the proposition that it is the nature of the legal aid which is the gateway criteria rather than necessarily the proceedings in which the matter is being heard. So the effect of the change in 2013, which I'm going to come to, whereby contempt for non-compliance with the civil order became funded by criminal legal aid, brought with it two fundamental changes so far as recipients of that legal aid was concerned. The first is it was no longer means tested. And the second was, as a consequence of the nature of the legal aid changing, the spectre of the contribution order then arose. Because, of course, the contribution order, so far as contempt for non-compliance with civil order is concerned, could not have arisen pre-2001 because it was civil legal aid and therefore the legal aid was not funded as part of the criminal defence service.
Well, you're using the phrase criminal legal aid. Is that a synonym for criminal proceedings funded as part of the criminal defence service?
Criminal legal aid is a reference to the statutory authority pursuant to which the legal aid is granted. Section 14. Exactly, Section 14 of last.
What was it then? Access to Justice Act?
The Access to Justice Act was Section 12.
Yeah.
So the way that both the 1999 Act and the 2002 Act work is there is a definition of criminal proceedings, Section 12 and Section 14 respectively, and then there is an obligation for funding in respect of those proceedings to be instituted. And the reason why the change in 2013, or rather the mechanism for the change in 2013, was to bring in under Regulation 9 of the General Regulations, which is the catch-all any other type of proceedings so determined, regulations propounded by the Lord Chancellor, Article 6, potential Article 6 infringements where they hadn't previously existed. They had been simply funded as part of the civil legal aid that means tested, as I will go on to show. So far as the pre-2013 position is concerned for contempt, in my submission again, it's important to properly define what type of contempt is engaged. So pre-2013, any contempt in the face of court was subject to criminal legal aid, wherever you were, irrespective of whatever court it was, and you were subject to a recovery order. Contempt for non-compliance with a Crown Court order was also criminal legal aid, subject to a recovery order. It was only non-compliance with a civil order that sat out with the criminal legal aid regime, and that was dealt with under civil legal aid. The case of Bunning at page 26 has, the case itself starts at page 24. And it's at page 26, paragraph 6 to 8, that the description of what took place up until the changes of the 2013 Act is set out. And in paragraph 6, committal for breach of an order of the court has been regarded as quasi-criminal in nature as a form of civil procedure for the purposes of legal aid. People seeking legal representation would have made an application to the Legal Services Commission, so that's the body that deals with civil legal aid, that then would have considered under paragraphs 3A 048 and 3C 026 of the then Funding Code Manual, along with paragraph 3C 61. Paragraph 7 is the defendant making the submission that it was unclear what the current position was, and then paragraph 8 sets out my client's position. It's the first sentence of paragraph 8, in which the legal aid agency made what was turned out to be a rather bold submission that the current law is being clarified and simplified. But certainly that was the intention. It was to bring in this particular type of contempt within the criminal legal aid sphere. My lords, at the bottom of paragraph 6 are 3 specific paragraphs of the Funding Code Manual, which is set out. The relevant parts of the Funding Code are set out from page 426. The code itself isn't particularly helpful. I'm going to refer, if I may, your lordships, to it simply for the proposition that is, if there were any doubts, which I don't believe there is, civil legal aid, one can see it plain as day at page 431. This is the Funding Code, Civil Legal Aid, in section 14 talks about quasi-criminal proceedings.
Well, prior to 2013?
Prior to 2013.
Well, I don't think there's any dispute that what Justice Blake said in the Bunning case is correct.
My lord, if I may then, as I move through, just take you to the hand-up authorities which were placed in front of your lordship.
Yes.
There are 2 paragraphs in this clip that I intend to take your lordship to. The first authority is the 5-page extract from Arledge, which deals with the Access to Justice Act position. And it's paragraph 15142, which summarises a case called Williams-Jones. If I could just invite your lordships to read 15142.
Whose decision was Williams-Jones?
This was Sir James Munby making the point, and this is simply the authority's summary of that decision. I'm going to come to that decision, but simply making the point that in the case before him, he understood, and it was a function of submission, that public funding for non-compliance with a civil order had not been given because of a failure to comply with the means testing, then being required for the purposes of civil legal aid. And at paragraphs 42 and 43 of that decision, which you'll see at page 451, he expresses his dissatisfaction with that. Yes. My lords, I take that decision just simply to provide some comfort for the written submission I make in my second argument, which is that it's always been my client's understanding that where it was civil legal aid pre-2013, there was means testing involved, and here we have an outright expression of that.
Well, I shouldn't give evidence, but it was my recollection that in civil proceedings in the High Court, where somebody was alleged to have committed contempt, not in the face of the court, there was a constant problem that plainly they needed legal representation, and the legal aid authorities in those days might take months to decide whether they could have it. And in the meantime, what did you do with the contempt proceedings?
My lord, this case is an example of that,
Yeah.
because before Sir James Mundy, council had to act pro bono, simply because the funding had been declined because there had been assets in Spain. If we now fast forward to 2013 and have, and then considering the position as it is today, there is means testing for representation in the Magistrates' Court and in the Crown. And
so Magistrates' Court and Crown Court.
Magistrates' Court and Crown Court, there is means testing for legal aid. At the final page of the authority clip that I handed up, you will see part 3 of the funding regulations, and it's just regulation 18, which sets out the financial eligibility for representation. This is in the Magistrates' Court. The Crown Court was in the bundle, and it occurred to me that it would be useful for your lordships just to be aware of that. One thing, if I may, when you're looking at regulation 18, aside from noting that the actual amounts which are relevant are delineated to the pound, there is a recurring figure that one sees, which is also in the recovery regulations themselves, which is that figure of 22,325, which is the final figure at the bottom line on regulation 18. I have no idea why that exact figure seems to feature so prominently in the various contribution and or means tested regulations, but it is there nevertheless. And I think I put it no higher than this. It just supports the proposition that this is a specific and intended to be stitched together system. I don't think I can put it any higher than that, but it is notable that figure of 22,325 does seem to rear its head a number of times. With respect to the Magistrates' Court, there is no contribution regulation involved at all. So if you are means tested in the Magistrates' Court and you satisfy that, you are not liable to contribution regulations. In both the Magistrates' Court and the Crown Court, children are not means tested. They are not subject to contribution regulations. My lords, in the second section of...
So I can understand how that works. If there's means testing but no contribution, so provided you pass the means test, you get legal aid, no question of paying for it.
Yes,
if
the
you
Magistrates'
don't pass
Court.
the test, you pay for yourself.
You pay for yourself, and in the Magistrates' Court, the availability of legal aid is indelibly tied to... There are, if I just take you to section 16, in the Magistrates' Court, the decision maker is the director. It's section 16 of the last.
Do we need to know this?
The short answer, my lord, is no, but it's section 17. Section 17.2, the director will look at the offence in the Magistrates' Court, and unless you've got specific learning difficulty, there has to be a risk of imprisonment for legal aid to be available.
Yeah.
So in the Magistrates' Court, certain categories can, certain categories can't. If your means tested and you satisfy it, you have representation, and there is no contribution, and if you don't, you are left without public funding. In the Crown Court, and it's the finance regulations in the Crown Court, it's page 357, sets out the financial eligibility for representation, and again we see this similar pattern of identifying income. The means testing is not a function of capital, it is a function of income. But of course, given that the disposable income thresholds are so low, in the Magistrates' Court, it's 3,398. In the Crown Court, it's slightly greater than that. Regulation 31 defines that is the means testing. And in both Crown Courts and Magistrates' Court, the primary decision maker is the director of the legal aid agency. So far as the changes are concerned, what it meant for this specific type of contempt, because the other three types of contempt, and by that I mean face of court for criminal and civil, and for non-compliance with a criminal order. Civil is now brought into harmony with those. The practical differences, so far as a contempt for non-compliance with civil order is concerned, as at 2013, is that it was previously means tested, it is no longer means tested. And if one goes over the page, at page 358, we have the deeming provision that so far as criminal proceedings other than the Magistrates' Court and the Crown Court are concerned, the authority must make a determination of the individual's financial resources as such the individual is eligible. So it's Regulation 39 that provides that for any criminal proceedings, save for those and those courts, that includes the county court, for example, if there is non-compliance with a county court order, there it is deemed that the eligibility requirements have been satisfied. So if there was a contempt of a civil order at 2013, they no longer are means tested. But in the Respondent submission, the counterpoint to that is that that individual then becomes within the scope of the recovery regulations.
It's not in dispute, is it, that criminal proceedings here, in Regulation 39 of the Financial Resources Regulations, has the meaning that it otherwise has under the Act?
No, and part of the reason why it's not is because the All England Authority, which is authority for, if I might take you to it, the proposition of what those words criminal mean, proceedings mean in a variety of statutes. And that's at page 8. And it's the discussion of Mr. Justice Chamberlain.
So, before we go to that, that's the All England case, isn't it?
Yes, yes.
I thought the regulations which we've just been looking at, using criminal proceedings, the authority for it is derived from section 14H of the LASPO,
Indeed.
and thus ties in with Regulation 9 of the Criminal Legal Aid General Regulations, also
Indeed, my lord.
made under that statute, and page 350.
Indeed, my lord.
That's disputed, is it?
It's not disputed.
No.
It is common ground
Yes.
that so far as Regulation 39 is concerned, criminal proceedings means those in section 14H.
Yeah.
It is also common ground so far as Regulation 21 of the General Regulations. Regulation 21 of the General Regulations is the interest of justice test. So if one turns to that, which is at page 355, your lordships will recall that criminal legal aid cannot be provided unless the interest of justice and the funding tests have been met. And if one goes to Regulation 21 at 355, again we have the deeming provision for, again, and the words are criminal proceedings. Without definition, Regulation 21 at 355, the interest of justice test is met for the proceedings set out in A to D. And again, there's no dispute that criminal proceedings is that expression is set out there, as with Regulation 39 of the financial regulations, includes the present proceedings. And indeed, takes its definition from section 14 of LASPO, which is at page 324, which is, of course, what's naturally man below included and is consistent with the Respondent submission that criminal proceedings, as that expression is used in the recovery regulations, means exactly the same as it means in LASPO, as it means in Regulation 39 of the finance regulations and Regulation 21 of the general regulations. if I could just orientate your lordships in LASPO just for a moment, just
Yes.
to properly explain its operation. Section 14 at page 324 defines criminal proceedings. Over the page at 325, section 16.1 provides the representation is to be available if the individual is a specified individual. Specified individual is defined at the bottom of that page and the top of the next page, and links the individual to the type of proceedings in section 14. That's little a and b at the top of 326. So you have to be a specified individual in relation to those proceedings in section 14. Section 16.1b provides that the relevant authority has determined that the individual qualifies in accordance with that part. Relevant individual is defined below, and it's the persons authorised under 18, 19 or 20, and that means the director of the legal aid agency or the relevant court, depending on which of those regulations is engaged. Over the page, section 17.1 provides that the relevant authority, which again is the decision maker, must determine whether an individual qualifies under this part of representation for the purposes of section 21 financial resources, and that's what brings in regulation 39 of the financial resources regulations, and the interest of justice, and that is the provision that brings in regulation 21 of the general regulations that deals with interest of justice. And then again, my laws for good order on page 328, 23.2 is just the governing section that provides authority for the recovery regulations to have been propagated. My lords, I will, if I may, just in this second section as I bring it to a
Yes,
close.
you're going to take us to the Wimbledon case.
Yes.
And I stopped you. If you want to, then go ahead.
My lords, I don't, simply because the authority for which I was going to take you to it, I think, is undisputed, and it's simply that regulation 39 and regulation 21 and the general regulations mean exactly what it is that the respondent says it means in this case. And that is the authority for the proposition, albeit that it is not disputed. But if your lordships would care to take note of it, then it is there. The second section of these submissions is very briefly going to focus on inadvertent consequences were this appeal to succeed. The first is, and this depends to a certain extent on which of the three alternatives the appellant has put forward, so far as words to be interpolated in regulation 2 of the recovery regulations are concerned. But if the words are as it is in the written case, non-means tested appellate proceedings only, then if that were right, there would be a suite of proceedings which would fall by a side wind out with those regulations. So if it is right that you could only make a recovery regulation in appellate proceedings, then, for example, judicial reviews in the High Court would be taken out with the scope of those proceedings. Judicial reviews in the High Court are not appellate proceedings, and in my skeleton argument at paragraph 19b, I set out some examples of them. They're undisputed, so I needn't take you to them, but you have examples like challenging orders implementing extradition, challenging police cautions, jurisdiction issues in the Crown Court. They all take place by way of judicial review. The next...
They are criminal proceedings within the regulations. They've been held to be criminal causes or matters for
the purposes of appeal, yes, and likewise in the purposes of criminal legal aid. And there is a direct example of that, which one sees actually in LASPO itself in section 14 on page 324. Section 14F refers to proceedings on a reference under section 36 of the Criminal Justice Act on offensive law. And if it were right that the recovery regulations meant only appeals, then any reference under section 36 of the Court of Appeal would not be an appeal and by a side.
That may not be a very good example, because I thought when the attorney brings a Section 36 appeal, the respondent is paid for by public funds as of right, and so they should be.
It might not be a good point, my lord. I will refer to your greater knowledge. Page 312 is Section 36, but I certainly don't pretend to know the funding of Section 36.
There may be better examples. There's only a handful of those a year in contrast to hundreds and hundreds of sentence references.
Indeed, my lord, I'm sure it's a rarity, but as I say, Section 36 there and in the bundle were to be useful as an example. And of course, you have a number of types of proceedings that were formerly subject to a recovery order under the 2001 regulations that would no longer be. Contempt in the face of a civil court, for example, would no longer be subject to it. And again, that is an inadvertent consequence. And the final inadvertent consequence is the effect of this appeal being allowed is that within a complicated suite of regulations that are intended to have reference to the governing legislation in LASPO, you would then have distinctions and divisions between them as to what criminal proceedings mean in circumstances where the issue is non-compliance with a civil order. And again, that's by reference to Regulation 39 and Regulation 21. Civil proceedings would mean different things in different regulations, albeit that they apply to the same proceedings. And in my submission, if one particularly sees that through the lens of Section 11 of the Interpretation Act, militates against the proposition that there is a contrary intention, and I would say, in fact, provides for otherwise. The final inadvertent consequence of this is that this type of proceedings, putting aside children for one moment, would be the only type in which criminal legal aid is provided for which there is no means testing, no interest of justice test, and no possibility of a contribution. Of course, on appeals, we have Regulation 8, which might be described as a presumption against it, but the proposition that there is, putting children aside, as I say, no means testing, no interest of justice test, but no ability for the court to make an order for contribution, this, certainly so far as I can't as well, would be the only type of proceeding, so to speak. Again, I'm taking children out of discussion. My lords, the next section of my submissions is to make the self-evident point that there are variations across the regime as a whole, and the fact alone that there are differences does not support the proposition that there is a contrary intention. Some of the variations I've made mention of. So far as contribution is concerned, as I say, there is no contribution in the Magistrates' Court. In the Crown Court, you've got the contribution regulations, and there are, as I will go on to show, stark differences between the contribution regulations in the Crown Court and the recovery regulations for all other courts apart from magistrates and Crown Court. And the fact that there are differences does not, in my submission, support the proposition there is a contrary intention. If I can take your lordships to page 387. In the Crown Court, you have what's described as income contribution orders. They don't exist in the higher courts, or rather I should say other courts, because the county court falls within the recovery regulations. Regulation 12 is the means testing element. And more importantly, 12.2a provides for an income contribution. So if you are within the purview of the means testing element, then you are subject to an income contribution order, which is 1/12 of 90% of the individual's disposable annual income. And that lasts for the duration of the matter until one gets to page 389. The capital contribution is assessed by the director. This is Regulation 25. there will be the first step prior to the capital contribution is that the director has got to calculate the cost of representation. The director has to calculate that cost under Regulation 25. If there is a sentence, so 25A, guilty verdict and a sentence, 25B, the trial judge provides, or 25C, funding is withdrawn. And that might be because the interest of justice test is no longer met, for example. In those circumstances, in Regulation 5, the director has got to calculate the cost of representation. Regulation 26 provides for the judge to have power to make an order specifying that only a proportion of the cost of representation for which the individual is liable is to be paid, and that bears similarities to Regulation 5, the recovery regulations. Regulation 27 on 391 provides that having ascertained the cost of representation, the director must then assess the individual's capital in accordance with Regulation 28, and at 392 is Regulation 28. Regulation 28 1B, for example, deducts £30,000 from the total amount of value. Now, under the recovery regulations, there are different thresholds. One deducts the first £100,000 of the legally aided party's home, for example. So that's Regulation 28.1. Another difference between them is Regulation 28.3b provides that any asset restrained by the order of the High Court is to be ignored for these purposes, but it is not ignored for the purposes of the recovery regulations. And again, that is a difference, because differences permeate the entirety of this regime rather than support the proposition of RDCO country orders. And at 395 is the issuance of the capital contribution order. Now, if one juxtaposes that to the recovery regulations, the differences between the regimes are apparent. So in the recovery regulations, by way of example, Regulation 5 at 378 bears some resemblance to Regulation 26 of the contribution regulations, in that in both circumstances the judge making the order can make a proportionate order. So that's Regulation 5, the recovery regulations, and it's 5.1b at 378. So to that extent there's a degree of harmony. There is also a degree of harmony when one looks at Regulation 8. Regulation 8, and so far as the Crown Court is concerned, Regulation 37 have a degree of similarity which governs appeals. But it's important, so far as Regulation 8 is concerned, not to take its terms in the respondent submission too far. It's only engaged 8.1 in respect of every conviction an appeal is allowed, but nevertheless the court retains the jurisdiction to make a recovery order if it's reasonable in all the circumstances of the case. So the way that Regulation 8 operates is to confer jurisdiction but to provide a different presumptive starting point than that in Regulation 5, but it doesn't go beyond that. It doesn't automatically take out all appeals, so to speak. It simply reverses the presumption. Over the page at Regulation 10, the exceptions are different from those in the Crown Court. The Crown Court, as we've seen, it's the first 30,000 and that's it. It's more generous here under Regulation 10 and Regulation 15. And again, we see that slightly mysterious figure of 22,325, which appears in the means testing in the Magistrates' Court again. I can't possibly divine it, but I make these points, Michael, simply to support the proposition that it is possible to find common threads through these various different regulatory regimes, but I wouldn't put it any further. There are differences between them, and they are often differences that don't for any particular explanation. Why it is that that figure of 22,325 crops up in different regulations is a mystery. Equally, why it should be that under the recovery regulations, even though there is no means testing, it is much more generous to the legally aided party than in the Crown Court, because one ignores the first £100,000 of one's principal primary residence, rather than simply the £30,000 in the Crown Court. Again, is a proposition for which there is no obvious explanation. The regimes might have a common thread, but I don't think one could put it any further. And again, the fact of difference doesn't support the appellant's case in the respondent's submission. And so far as appeals are concerned,
are we still on unintended or accidental consequences of Mr. Maloney being right?
No, my lord, and the error is mine. My signposting is obviously not what it should be. This third set of submissions is simply to provide support for the proposition that there are differences embedded in the operation of this system, and the fact of differences alone does not provide the contrary intention necessary in the respondent's submission. So, as I say, the differences are whether contributions apply. Magistrates' Court it doesn't, but others it does. The differences are in the thresholds for means testing. The differences can be seen that in the Crown Court one has an income contribution order which is unique to the Crown Court. But in these recovery regulations, they are much more generous to a legally aided party than those in the Crown Court. And again, my lord, the submission here is the fact alone of these differences are simply a feature of the legal landscape rather than providing any support for a contrary intention so far as the construction of the recovery regulations are concerned. And so far as appeals are concerned, in the Crown Court at page 396, Regulation 37 provides if the Court of Appeal allows an appeal against conviction, then the sums paid under an income contribution order and a contribution order in the Crown Court are to be repaid. So far as the recovery regulations are concerned, and again, I've taken your lordships to Regulation 25 that provides that the process of coming to a capital contribution order is triggered in Regulation 25 if an individual is sentenced. So again, one sees in the Crown Court that if there is an acquittal, income contributions are to be paid back. And if a capital contribution is made, which presupposes a guilty verdict, then when our appeal is allowed, the capital contributions to be paid back. So far as the recovery regulations are concerned, well, Regulation 8 is different. Again, it has to be total acquittal and the jurisdiction remains. But more importantly, where one faces the situation that the civil contemnant who is found innocent is concerned, well, of course, you've got the costs order in the civil jurisdiction that will offset the fact that there is a presumption for an order being made, unlike an appeal in Regulation 8 where the presumption is against it. Now, so far as the recovery regulations are concerned, they provide a great deal, in my submission, of room for the judge faced with the issue to make an order that reflects the justice of the case. And Regulation 5 of my learned friends exchanges with my Lord Justice Zacaroli is an example of that. So Regulation 5b is a proportion of the cost of the individual's representation in the proceedings as the relevant court considers reasonable, having regard in particular to the financial resources of that individual. So if one was faced with a situation which is not that here, where the contemnor is found innocent, then, as my learned friend rightly concedes, there's no principled reason why the court shouldn't make an RDCO expressly limited to the amount that the legally aided party recovers from the other party pursuant to the civil cost order under Part 44. Now, if that were the case, And if that were to take place, then one sees a direct line to the 2001 regulations, which provide on acquittal there shouldn't be a contribution. The direct line to regulation 25 of the contribution regulations in the Crown Court, which provide, again, unless the judge provides otherwise, the aided services are withdrawn, that on acquittal there shouldn't be a contribution. One can, without doing violence to this particular statute, if the court was concerned about finding a consistent policy theme from 2001 to 2013, that would be the mechanism of doing it, rather than unilaterally taking a raft of cases out of the purview of the regulations and creating, with the exception of children, this unique set of circumstances in which the state is bound to fund, irrespective of means, irrespective of interest of justice, with no ability to cover. The next variation, so to speak, as I come to an end, are, so far as these third sets of variations are concerned, is that there are substantial variations in the criminal legal aid and the civil legal aid realm. And in the context of contempt, that is shown, no better shown in my submission than in the hearing case behind tab 10, and I will just take your lordships very briefly too. In that case, which is behind tab 10, starting at page 142, this was a case where civil contempt for non-compliance with a court order, and the question was the contemptor having been found guilty, should Part 44 costs apply? And the relevant discussion starts at paragraph 7 on page 147. The judge in question made a full costs order. The legally aided party was to provide the cost in the sum of £25,000. We see that from paragraph 3 on 146. Judge ultimately ordered Mr. Kukurian to pay £25,000. The arguments at paragraph 7 were that what the court should do is transpose from the civil legal aid regime the type of cost protection which exists in section 26 of LASPO into the criminal aid regime. What 26 of LASPO provides is that a cost order is to be expressly limited. We see that at paragraph 18 on 149. So 18 is section 26 of LASPO, which limits the costs. Paragraph 19 makes the point, well, that doesn't apply because the legal aid is now criminal legal aid. So it's paragraph 19. And at paragraph 24, the Court of Appeal simply said, well, that's a matter for Parliament or the CPI. Because the injustice that was being complained of was that to provide the full rigour of CPR 44 costs was fundamentally unfair, and then various convention rights were to buttress that argument. But the Court of Appeal's answer was, well, that there are substantial differences, to note them, but to simply say that's a matter for Parliament. And at paragraph 50, the Court of Appeal made it clear on 157 is a broad generality, the approach of the court to an award of costs in a case of contempt of court is the same as in any other form of civil proceedings. That's paragraph 50 on 157. And again, my lords, this is an example of a variation between, in this case, the civil legal aid regime and the criminal legal aid regime. And when the matter came before the Court of Appeal, with one party saying, well, it's not fair that had the legal aid been different, cost consequences would have been different. this is not the order, but it's whether Section 26 would provide a defence to that order. The Court of Appeal said, well, that's a matter for Parliament. And the differences so far as civil contempt and criminal contempt are concerned, which are themselves a function of the recovery regulations as against the contribution regulations, are not nearly as unfair to those subject to the recovery regulations as the appellant in my submission makes out. If you are facing contempt in the Crown Court, you are means tested, you have income contributions to make throughout the matter. Your capital contribution protection is much lower, it's £30,000. Whereas if you sit outside the Magistrates' Court and the Crown Court, there is no means testing at the outset, there's no obligation to pay during the currency of the lifetime, and the recovery regulations don't bite on, for example, the first £100,000 of primary residence. So even on the respondents face the position of a legally aided party facing civil contempt proceedings is measurably better than that same party were the proceedings to be contempt in the Crown Court. My lords, the final point I make as I draw these submissions to a close is one which deals with injustice so far as this specific appellant is concerned. At page 158 of the supplementary bundle is the representation order which was granted to the appellant. It's 158 of the supplementary bundle. This is April 2023. And in the representation order itself, the appellant was expressly told that the court hearing these proceedings may make an order under the 2013 recovery regulations. It's page 158. It's the three-line paragraph, final three-line paragraph.
What on earth is the £1,574.06 figure?
So when one gets a representation order, there are caps that are put on it, which will get bigger and bigger as the matter progresses. So that will undoubtedly, I suspect, be for initial advice. And it was after the initial advice proceedings were issued, and then the cap gets greater until it takes on its current amount, which is some £400,000, 392.
Yes.
So that would have been it. And, my lords, I accept that's a make-weight. Well, it's not even a make-weight, it's not even a jury point. But so far as injustice is concerned, in circumstances where the appellant chose to avail himself of legal aid, where it was not being tested and was told in advance of the risk of this order, insofar as this court is inclined to any sympathy, the respondent could suggest otherwise. My lords, my final point is simply to remind the court, if I may, of the lens through which this appeal is to properly be seen. The appellant faces the challenge of showing that there is a contrary intention. And my learned friend made submissions so far as the case of Kudak is concerned. And so far as the contrary intention is concerned, or the respondent's position is, in fact, the regulations that I've taken this court to state the very opposite. And the fact of variation alone is insufficient so far as contrary intention is concerned. And with respect to the backup argument, which has been run by the appellant, which is probably part and parcel of the contrary intention, but if not, there was a form of intended purpose of the statute which was not reflected in the 2013 regulations which justifies one of the alternative interpositions of wording that's put before this court. I do remind this court that if one looks at KDAR at 69, we are light years away in my submission from the type of case in which this court can conclude that in the 2013 regulations, Parliament had an intended purpose of the sort the appellant submits, that there was the inadvertence that the appellant submits, and that a form of wording should be interpolated in Regulation 2, particularly in circumstances where it is certainly not clear to the respondent as to what that form of wording should be. My lords, I'm not going to take you to KDAR unless it will actually assist, but as no doubt you would have seen from that case, in circumstances where the government propagates exactly what it is that it wants the rules to say, directs the Rules Committee to reflect that in the rules, and the Rules Committee didn't, the court was prepared to set foot into the territory of rewriting those civil procedure rules. But in my submission, we are far removed from that set of facts in this particular appeal. I might turn my back for a moment. My lords, unless I can assist you further, those are my submissions.
I'm maybe being a bit slow here, and this may not be vital, but 22 of your skeleton refers to the explanatory statement for the 1999 Act. And it made the point that the system of means testing in advance was getting too expensive. We were spending £5 million on means testing, and legal aid was only £6 million. So that was changed in the 1999 Act. But we seem to have gone back with 2013 regulations or regime to means testing in the Crown Court being the norm. Am I right in that?
Yes, but the means testing itself is done by the Director of the Legal Aid Agency. So that's the critical distinction in terms of procedure. So far as the High Court and above is concerned, those courts have power to grant representation order. There is a right in the Crown Court. It's very heavily circumscribed. So the Crown Court can grant a representation order in and of itself. Ironically, if there has been contempt of itself in Section 16, so it can do that. But other than that, it's a matter for the Legal Aid Agency, and what the Legal Aid Agency does is have a form of approved suppliers and the like, and it does that means testing, so to speak, itself. So the critical change is, yes, means testing is being reintroduced, but it's not the court that does it.
Right.
It's the LA.
And it's thought to be that would be cheaper.
Indeed. I mean, whether that's proving to be the case or not.
Yeah.
I'm grateful.
Yes, Mr.
Well, thank you. Just a number of, I hope, fairly short points in reply. May I start by dealing or coming back to a question that the Lord Justice Zacaroli raised before the luncheon adjournment, and which Mr. Cohen has also addressed, which is the proper interpretation or application, perhaps is the better expression, of Regulation 5 of the recovery regulations, which is in your bundle at page 378. And so this, Lord, it is the question, trying to avoid repetition of everything that's gone before, this is the question of whether and to what extent the prima facie exposure of an alleged civil contemnor to repaying the costs to the legal aid agency in circumstances where he has been acquitted may be mitigated by the court's exercise of its jurisdiction as to the order it makes. And so, Lord, in this regard, I think if I have it correctly, the proposition that was raised, or the question that was raised, concerned the question of whether it was open to the court in those circumstances to make a determination, which was essentially a contingent determination, such that the liability to repay to the legal aid agency was limited to the extent that adverse costs were recovered against the unsuccessful applicant in those proceedings. And so, Lord, I have to accept, although I'm not aware that any such order has ever been made, perhaps unsurprisingly, given what we've heard about the limited use of these regulations in the context of contempt proceedings. In fact, they're not been used prior to this case. In principle, Regulation 5 appears to give the court a discretion to make a determination which may be limited to a proportion of the cost, the individual's representation. And that is not limited to just having regard to financial resources, but having regard in particular to financial resources. So, my Lord, I'm not going to suggest that in principle that order would not be open to the court, just as in response to the question before the lunch and adjournment, I didn't. What I do say is when we look at it in context, that doesn't appear to be what these regulations are contemplating the court doing. And so, my Lord, if we just follow this through, if we look at Regulation 6, which is immediately below on the same page, we can see that the court has to record its determination made under these regulations, has to give reasons, and then at sub 3, it may provide either for immediate payment of the full amount payable in respect of the determination, or for periodic payment of specified instalments. So just pausing there, what these regulations appear to be anticipating is a single determination by the court which will quantify a sum which is either to be paid in full or it is to be paid periodically. Again, I don't say that an expansive view of Regulation 5 is not possible, but it certainly doesn't appear to be what was contemplated. Lord, we say that again if we follow it through, because later on in these regulations at page 385, we have provisions which deal with, firstly, overpayment, Regulation 19, and secondly, the enforcement of an RDCO. And so Regulation 19 deals with the question of overpayment if it subsequently transpires that, in fact, the true cost of the representation is less than the amount that they were ordered to pay. So again, that appears to operate on the assumption that at the conclusion of the proceedings, subject only to the remaining provisions of these regulations, which anticipate the gathering in of evidence as to financial resources, the court will make an order to pay in a quantified sum, which will either be payable in full or payable by instalments, with a prospect at some point that if it turns out that in fact the total cost was less than that amount, that there might be scope for a repayment from the Lord Chancellor. That is not, we say, it doesn't speak of these regulations being anticipated to make some kind of contingent order which is dependent on what might happen in continued proceedings between the alleged contemner and the unsuccessful applicant, whereby the alleged contemner is seeking to enforce any costs order that might have been made in their favour. And just pausing there, of course, that also leaves open the question of how the alleged contemner would fund that. It may be, and I go no further, that they could possibly obtain assistance from the legal aid agency to do that, but what they certainly wouldn't be able to obtain is legal aid assistance for any enforcement against the unsuccessful applicant. And so that comes to a separate point, but a related point, which is our point, of course, that the legal aid agency's construction of these regulations as a whole, if they are correct, would have the effect of leaving the successful respondent to an application for contempt essentially hung out on a limb, whereby they would essentially be effectively presumed to be subject to an RDCO, even if acquitted, and where it would be left largely to them to seek to mitigate that by seeking assessment of and in due course enforcement of such costs as they can get from the opponent, subject only to the question of whether the court is going to embark on a process which the regulations don't appear to anticipate of in fact making some contingent order against the respondent. So where we say that leaves us, my lord, is that we say that the intention of these regulations appears to be for a quantified order to be made at the conclusion of the proceedings, subject only to provision of financial resources. And that emphasises the injustice that we say would arise if my learned friend is correct about the scope of these regulations. Lord, more generally, moving on to a separate point, a part of my learned friend's submissions, or a significant part of his submissions, relates to the argument that there is a coherent and identifiable policy here, which involves the shifting of liability from a means testing approach to one where the obligation is instead to pay a contribution at the conclusion of the proceedings. And in broad terms, without doing justice to everything that's been said, the submission that is made is that that is a logical policy, and if we consider the RDCO regulations on their face, they are just a manifestation of that policy, which is that for the sort of proceedings that we are talking about, the individual who may have been, it would appear, certainly from such limited assistance that we have from the extract from Arledge and the case that's referred to in there, who may have been subject to means testing prior to 2013 for proceedings of this type, are now instead simply subject to a contribution order at the conclusion of the proceedings. And if that's the logical policy, we are told, well, what is the problem? In relation to that, my lord, our position is, as I indicated before the lunch in German, we do not push back against the principle that there may be scope for a coherent policy which requires individuals who receive legal aid in response to enable them to respond to contempt applications to be required to contribute to the cost of that representation. We wouldn't dispute the proposition that there is scope for a coherent policy, that they may be subject to some sort of means test, if that's thought appropriate. Some sort of financial eligibility testing for that sort of legal aid. But our point is not that there isn't scope for a policy, but that the policy that Mr. Cohen submits can be identified in relation to these regulations falls down when we consider the operation of these regulations. Because, first of all, we know that the policy prior to April of 2013 was not to have recovery orders made in respect of individuals who are subject to proceedings of this type. If my learned friend is correct, then there was a policy to make that change. And if my learned friend is correct, there was a policy to make that change and to put those individuals in a different category to other individuals who were subject to the RDCO regulations. So not just to bring them in, but to treat them differently. And so it's not a question of Mr. Cohen saying it's possible to identify a broad, coherent policy of a general shift from means testing to contribution orders, because it falls down when you look at how, if that is the policy, it is supposed to have been enacted under these regulations. I come back again to the point that I've made, without again wanting to indulge in undue repetition, that the explanatory memorandum makes it very clear that there was no intended change of policy in relation to these regulations, that they are simply intended to reenact in the scope of the 2013 changes the effect of the 2001 regulations. And so even if it were correct that it could be said, well, the inclusion of individuals who were not previously subject to contribution orders in these regulations is because the general scope of the 2013 changes is to move individuals who are no longer subject to means testing to contribution orders. It doesn't deal with the fact that there must have been a policy to treat them differently. And that is the fundamental problem why we say it's a proposition that these regulations can be properly interpreted to apply to individuals who are subject to proceedings of this type is illogical. It does not function, and it cannot be cured, and I'll come back to this briefly in a moment. It cannot be cured by the reference to the possibility of them seeking some form of compensation by an adverse costs order against an opponent. Again, if that was an identified policy to say we are going to treat these individuals differently, and the reason we are going to do so is because they have this ability which is not otherwise referred to in these regulations, and therefore we are going to leave them in an ostensibly more disadvantageous position, but they may be able to mitigate that. That is exactly what we would expect to see, subject to a consultation. This is exactly what we would expect to see set out in an explanatory memorandum or in a consultation document, and it features nowhere because we say it obviously was not the intention. May I come then just again, I hope briefly, to the question of wording. I have been taxed by this court, and Mr. Cohen has taken the point, obviously for sound forensic reasons, as to what we say is excluded from the scope of Regulation 2 of the Recovery Regulations. And I come back again to what we say in the grounds of appeal. We are, in this case, concerned with our client who has been party to what we describe as civil contempt proceedings, and I'll come back to that in a moment, who has been subject to civil contempt proceedings. Our case is that when you look at the recovery regulations, it cannot be correct. It would be illogical for the reasons that we have given, that these regulations apply to a client such as ours, who has received legal aid for those proceedings through the ambit of Section 14H of the Act. That is why we say what plainly cannot be included are civil contempt proceedings. Now, if, as Mr. Cohen seeks to indicate, that if the logic of our argument is correct, if the consequence of that is that Regulation 8 and the recovery regulations generally cannot also apply to other individuals who may have received legal aid in other forms, well, that is, with the greatest of respect, a matter for the legal aid agency to deal with on any case where that arises. We don't need to, and nobody has sought to take this court through every paragraph of Regulation 9 of the general regulations to look at the question of whether those cases are ones which might even fall within the scope of the recovery regulations, and whether there are any other significant categories of cases which might fall away if our argument is correct. Mr. Cohen took you to Section 14F of LASPO to refer to the position of Section 38 CJA 1972 cases, and for the reasons discussed in court, that wasn't a good example for obvious reasons. But it might be thought that there was more force in his point if he were to take you to Regulation 9, that is those other cases which fall under 14H, and to go through those cases and say, look, here are category after category of case which would be subject to the recovery regulations prima facie, but which, on the appellant's argument, would fall out if they are right about civil contempt proceedings falling out. But that's not an exercise he has done, and with respect, it's an exercise for the legal aid agency, because we are concerned with our client in this form of proceedings. And if the legal aid agency's response is that if we are right, it would give rise to manifest problems in all of these other forms of proceedings, well, that was a point for them to make good, and it's a point that they haven't made good. So that is why we have tried to keep the focus of what we say is outside Regulation 2 narrow, because that's all we need to do for the purposes of this appeal. And we invite this court to do no more than what we have said, which is to identify that it is clear that Regulation 2 of the recovery regulations cannot have been intended to include civil contempt proceedings within its ambit. And civil contempt proceedings is, if I needed to develop any more, what we mean is contempt proceedings in civil cases which have fallen within Regulation 14H. That's not me advancing different wording, that's just for the avoidance of doubt me explaining what we mean by civil contempt proceedings. Contempt proceedings in civil cases where we have got the benefit of Section 14H legal aid. That's as far as we need to go, that is as far as we do go. We don't accept the proposition, which as I say was not fully developed, that if we're right about this, it is going to give rise to manifest problems. That was an argument that wasn't really developed to any significant extent in front of you. But that if that is right, and if there are other cases where others might say, well, if that's correct, we also can't be subject to the RDCO regulations, well, that's a matter for them. Or if the legal aid agency really wanted to say that's going to cause us a major problem, that's either a matter for them to advance that before this court, or of course, the other point which has perhaps gone unsaid all the way through this is the legal aid agency is of course the perfect body to seek reform or amendment to these regulations if it thinks it's appropriate to do so. So Lord, just in terms of further short points, a point was made that the legal aid that my client has had the benefit of is not means tested, has no merits test, and if we are correct in relation to our argument, no possibility of a contribution order being made. Just in relation to that, just 2 points. The first is in relation to the absence of means testing. It's no part of my argument, and I have not advanced an argument that legal aid for contempt proceedings under Section 14H is means tested. I don't advance that argument. In my earlier submissions, I did refer the court briefly to the concern raised by Lady Justice Sharp in the Tiernan and NFU case as to whether that is in fact correct, whether or not Mr. Justice Chamberlain in McKay may have misunderstood or misinterpreted the regulations, and it may in fact be means tested, but that's an issue that can be resolved in other courts if it arises. We are proceeding for present purposes on the assumption that it is not means tested.
So you're proceeding on the assumption that Regulations 39, in Regulations 39, criminal proceedings has the same meaning as it does under Section 16?
Yes, absolutely. And my Lord, in relation to that, again, the point was put very cogently by Mr. Cohen. He said, well, if they are right about this, then the effect of this is criminal proceedings will have a different meaning in some of these regulations from others. And that is correct. The meaning in the RDCO regulations, the recovery regulations, will be narrower than the meaning in some of the other regulations. That is the obvious effect of our argument. But I don't accept the proposition, insofar as it's advanced against us, that that is a conclusive reason to mean that we must be wrong. Because if we are right, that if these regulations do apply to proceedings of this type, they lead to patent absurdities, injustice and unfairness, which cannot have been intended, then the only logical corollary from that is that they do not apply to those proceedings, and that the RDCO regulations do have a narrower scope and do carry with them a narrower meaning of the term criminal proceedings than where that term is used in other regulations. And I did make reference in my earlier submissions, I won't take you back to it, that there are, of course, instances within these regulations where the regulations do specifically refer, for example, to Section 14H proceedings. This isn't one example. We have a general definition, and our position is when you look at that general definition in context, this is a situation where we are led to the conclusion that it is not as wide as it is, as it prima facie appears. But my Lord, yes, absolutely, we accept that it would mean that the term criminal proceedings in these regulations had a different meaning to its meaning in other proceedings. My Lord, can I then just come briefly, again, I don't want to repeat all of the submissions that have been made, but can I come back to Regulation 8 of these regulations and the point in relation to exceptions for acquitted individuals? Because Mr. Cohen it's page 379 of your Lordship's bundle.
Yes.
Mr. Cohen approached this with a degree of care, as ever. He described there being a degree of harmony between the contribution provisions in these regulations and the contribution regulations that apply to proceedings before the Crown Court. The problem with that is that that apparent degree of harmony falls down when you look at the detail. Regulations 37 and 25 of the Crown Court contribution regulations, which are pages 389 and 396 of your bundle, make it absolutely clear collectively that where an individual is acquitted, there will be no contribution order to be made against them, save where there are exceptional reasons. Anything that they have paid by way of income contribution will be repaid to them. As we have seen, the 2001 regulations made it very clear in relation to every individual they applied to that if they were acquitted, that was effectively the same position, that no RDCO would be made save in exceptional circumstances. The problem is that that degree of harmony that Mr. Cohen relies on has fallen down if these regulations, the 2013 regulations, apply to individuals involved in proceedings such as mine, because without explanation, without justification, and without reasoning, the exception for acquitted individuals is limited to those who have appealed against convictions. And so this category of what are in my submission, parties of particular character, those who find themselves subject to an allegation of contempt, those who find themselves exposed to all the consequences of that, including potential liability for civil costs without protection, as most criminal defendants would, of any sort of limitation to that liability, because they face essentially a civil applicant who's got no restriction on their costs. They are also subject to being treated very differently as to what will happen to them potentially if they are acquitted. And there's no explanation for that, and it's not a degree of harmony, it's a stark difference from the position pre-2013, and it's a stark difference from the position for those who are subject to legal aid in the Crown Court, where the position on acquittal is absolutely clear. And it is that fundamental point which we say remains unexplained by the legal aid agency. If there was ever a body able to stand before this court and say, well, here is the cogent explanation for that difference, here is the policy that we advanced to the government to explain why that was what we thought should happen, here is why that decision was made to do that, it is of course the legal aid agency, and that has not been done. There is simply no good answer, we say, and it's not a good, the possibility, the mere possibility of an adverse conduct order or some creative order by the court providing for a contingent RDCO is not a good answer to why, if that was the case, that wouldn't be expressly addressed in these regulations, or why there is no identification of that as being the policy, or as to why, put bluntly, individuals such as my client would be, when they were considering taking out legal aid, left hanging with that idea that even if they were acquitted, they might still be exposed to an RDCO. So Mr. Cohen finished submissions on that point by saying that if he was right about the idea that there was that degree of harmony between the Crown Court contribution regulations and these regulations, you can then see a coherent link and policy theme which explains why these regulations can be seen to apply to individuals such as my client in proceedings of the type we are considering. In my submission, the logical corollary of that is if he's wrong, then there isn't that coherent link, there isn't that policy, and the reason why these regulations would be said to apply to clients such as mine falls down. Well, subject to those points, unless your lordships have any questions, those are our submissions.
Thank you very much, Mr. Mallory. Thank you both for your helpful submissions. We will, of course, reserve judgment. We will send out a draft judgment in the usual way. You both know this, but I still have to say it. It's a draft, not in the sense that we want anything re-argued, but only correction of typos and obvious factual errors. The contents are confidential to the parties until the formal hand down, the digital sense, promulgation on the National Archive and so forth in the usual way. Thank you very much for your assistance.